Is a lasting power of attorney more important than a will? Experience has shown me that a lasting power of attorney is more important than a will. A will is going to decide what happens to your assets after you die, and a lasting power of attorney is for you while you're still alive, but you're no longer able to take care of yourself. Hi, I'm Mike Pugh, and this week we're going to talk about why a lasting power of attorney is more important than a will. First, what is a lasting power of attorney? Well, a lasting power of attorney, or LPA, is a legal document that lets you, the donor, appoint one or more people known as attorneys to make decisions on your behalf or help you to make those decisions. Prior to the lasting power of attorney, the older version was called an enduring power of attorney in England and Wales, and this was upgraded by the Mental Capacity Act of 2005. LPAs have been in force since 2007. From this upgrade, there are now two lasting powers of attorney: health and welfare and financial decisions. Health and welfare being the newer addition, as we generally are living a little longer and we're all going to need some help in the future. If you have the older EPA or enduring power of attorney, good news, these can still be effective, but only for financial decisions, and you will need a lasting power of attorney for health and welfare. How do LPAs work? In your LPA, you can nominate a spouse or friend or family member to act on your behalf when you're unable. In a financial decisions LPA, your attorneys can take over your finances and deal with your bank and other financial decisions, and doing this means you now share control, which is entirely the point. We're all going to need someone to help us as we get a little bit older. So be sure to appoint attorneys you can trust. Spouses and adult children are the norm here. In a health and welfare lasting power of attorney, your attorneys can speak to doctors and other medical professionals on your behalf, and this is very important when it comes to your care. Most people don't realize that the local authority can section you and have you removed from your home and placed into a care home. However, your attorneys can stop this from happening if they can demonstrate that you're not a threat to the wider community. You're not going to burn the house down. And most people do better living in their own home, so be sure to have a lasting power of attorney for health and welfare. Who needs a lasting power of attorney? Don't think that this is just for the elderly. Everyone over the age of 18 needs a lasting power of attorney. Accidents, strokes, early onset dementia, it happens all the time. The other day I was talking to a young couple who were expecting their first child, and we were talking about how they were helping their parents get their lasting powers of attorney, and I asked if they had done theirs. Cue the long pause. So I asked, what if you are in the car accident and not dead, just injured, and you've lost capacity? Are there family finances in such a way that you, as an individual, control only your accounts? Because most couples these days have separate finances. Can you access your partner's finances? And they both nodded and went, oh, yeah. Well, in that case, if you were to lose capacity and your partner is locked out, what's that going to do to your family? And they both looked like awful. They knew it would be terrible. Well, you need a lasting power of attorney, or you're going to need to overhaul the way that you deal with your finances, I suggested. And in the interest of full transparency, my 19-year-old son has a lasting power of attorney. You see, he plays ice hockey at the University of Leeds. And if anything happened to him and he ended up in the A&E, neither my wife nor I would be able to speak to doctors on his behalf without his lasting power of attorney. This is that important. So why is an LPA more important than a will? Well, true story. My uncle lived in Portishead and died in 2014, and he had a terminal illness. Correctly, he had all his documents in place, but of course, my aunt forgot to take them with her when he went into the hospital. What happened is the doctors refused to listen to my aunt as she wanted to provide some guidance and instruction on my uncle's behalf. And it was rather stressful because she was surprised they wouldn't listen to her. Most people think the doctors will listen to the spouse. That's not the case. Thankfully, we were able to get the LPAs from their home and deliver them to her at the hospital, where once she was able to show that she was the attorney for my uncle, the doctors now started to pay attention. It was very stressful and completely unnecessary. So pro tip here, be sure to keep these documents with you whenever you visit a doctor or a hospital. Problems happen while you're alive, and the problems generally are worse if you have a partner and children. Without your lasting powers of attorney, everything, and I mean everything, becomes much harder. Do not assume your family can access your finances or speak to medical professionals on your behalf. They can't. And if you don't have a lasting power of attorney and you lose capacity, your partner will then need to apply for deputyship through the Court of Protection. And this is a private court. It's not even public reporting. Now it gets worse, as the application can take between 4 and 6 months, and there's no certainty that you're going to be the successful deputy. In the very few cases that we do hear about, it reflects a very difficult process at the Court of Protection, and the cost can be between £4,000 and £6,000. And the court won't always rule in the favor of the partner. You see, the court's view seems to be that if you were meant to be responsible for your spouse or donor, then, well, they would have set up a lasting power of attorney. So now your partner is going to have to go through a very difficult and expensive process with no guarantee of success, just to pay the mortgage and continue to put food on the table. At the same time, they're caring for you as you're trying to recover, and they're trying to raise the family. And the court's decision could be just to appoint a local solicitor to be in charge. And so now your partner ends up paying the local solicitor just to access your accounts, literally to buy groceries. It's the definition of a living nightmare. So now you know why having a lasting power of attorney is more important than a will, in my opinion. Here's how you can get an LPA. You can do these yourself if you're good at legal documents. You can apply through gov.uk. The registration fee is £82 per LPA in England and Wales. A typical couple will need 4 lasting powers of attorney, that's 2 each, and this is about 80 pages of documentation. If you really want to make sure you get it right, and I'm sure you do, most professionals charge between £200 and £600 per LPA. So remember, lasting powers of attorney while you're alive, wills for when you're dead, and trusts for when you're both alive and after you've passed away. That's it for this week. See you in the next one.